Under the thin skull rule, the defendant must take his victim as he finds him. This means if he has a particularly vulnerable victim, he is fully liable for the consequences to them, even if an ordinary person would not have suffered such severe consequences. For example, if defendant commits a minor assault on the victim who has a heart condition, and victim suffers a heart attack and dies, defendant is liable for the death of the victim, even though such an attack would result in no physical harm to someone without a heart condition. This rule applies irrespective of whether the defendant was aware of the condition or not. Let's look at the leading case R versus Hayward 1908 that we previously discussed in a lecture. The defendant chased his wife out of the house, shouting threats at her. She collapsed and died. She did not physically touch her. She was suffering from a rare thyroid condition which could lead to death, where physical exertion was accompanied by fright and panic. Both the defendant and his wife were unaware she had this condition, and it was held that the defendant was liable for constructive manslaughter, as his unlawful act, in this case which was an assault, caused her death. The eggshell or thin skull rule applied. He was therefore fully liable despite the fact an ordinary person of reasonable fortitude would not have died in such circumstances. The thin skull rule also applies where the victim has refused medical treatment which would have saved them. In R versus Blaue 1975, the defendant stabbed an 18-year-old girl 4 times when she refused to have sexual intercourse with him. She was a practicing Jehovah's Witness and refused to have a blood transfusion which would have saved her life. The defendant was convicted of manslaughter on the grounds of diminished responsibility and appealed, arguing that the girl's refusal to accept the blood transfusion was a novus actus interveniens, breaking the chain of causation. The defendant's conviction was upheld. The wound was still an operating cause of the death. Here, I want to remind you of the facts and the decision in R versus Roberts. In that case, the victim had been given a lift by the defendant but jumped out of the car when he tried to molest her and injured herself. Jumping out of the car was found to be a reasonably foreseeable reaction, and so the defendant was responsible for her injuries. Though Justice Stephenson did say that if the victim did something daft and unforeseeable, then the defendant would not be responsible. So R versus Roberts was followed in Blaue. The defendant stabbed the victim, who would have survived had she not refused a blood transfusion because she was a Jehovah's Witness. The court said that the defendant had to take his victim as he found her, and so he could not say that her death was her own fault. There are a few ways to think about these two cases. Is this about foreseeability? Should we say it was foreseeable that the victim in Blaue would refuse a transfusion? Or perhaps that it's about voluntary acts. The defendant in Roberts acted without thinking because she was under attack. And in Blaue, the defendant's religious views meant that she could not voluntarily choose other than to refuse treatment. You can argue whether our religious views make our choices completely involuntary, considering that you can after all change religion or break religious rules in reality even if you feel that you cannot. Or is it that we are protecting two different circumstances for different reasons? One because the defendant should have foreseen that his victim would jump out of the car, and one because we do not want to blame a victim for her religious views. Would you say it makes sense that our rules on causation will follow our general understanding of causation, even if that does not fit a perfect set of legal principles? On this note, I am ending this session on causation.